opposition says, we have tried to legislate. That was a quote unquote. The last time I checked, a legislative process commenced with some sort of a tabling of a bill before Parliament. There has been no tabling of a bill before Parliament. Parliament has never been seized with this matter. We have had vacillations during a South African Law Commission process. We have had a position of where Mr. Radman, in his affidavit to the 2009 application, and we see that at 147.5 of paragraph, our affidavit, where he conceded that there had been consensus reached before the South African Law Commission. When the Muslim Marriage Bill was passed, there was a sufficient consensus that had been reached. That was backtracked later. And if you take a judge where they say, we couldn't do anything because there had been overwhelming dissent. Well, where are we sitting now? They're restarting a process in which they've had no open public consultation process. They say to us that we hope there's going to be some fruition, but the Minister of Home Affairs says, I actually have no control over this process. It's all with the Law Commission. And I can't even say whether it's going to warrant a bill. Ms. Gabriel's made submissions based on what was before the Law Commission. I sat here and I listened to it. It's reminiscent to what was in the Muslim Marriage Bill that's now gathering dust in the shelf. And in 587 of the record, at paragraph 38, the then Deputy Minister of Home Affairs said, I accept that I'm not in a position to provide this court with any certainty as to whether after a process of extensive consultation, a new Marriage Act will in fact find favor with the various communities. While I accept that it may not be possible to obtain consensus in respect of legislation of this nature, I emphasize that the state's clear preference is for there to be large support for such legislation. Now, we ditched one bill because we didn't have sufficient consensus. We're embarking on the process with another bill, and we're saying, well, actually, even if we don't get sufficient consensus, we may be satisfied with large support. That is a complete contradiction in its own terms. I want to draw this court attention to two cases. In AB versus Minister of Social Development in 2017, this court, in paragraphs 37 and 38, and the citation is 2017-3 SA 570cc, recorded the following. By 1992, the South African Law Commission had conducted the practical application of existing legislation, that was legislation regulating surrogacy, leaves much to be desired as it does not provide adequate protection for the parties involved. In paragraph 38, the court said, in the same year, the South African Law Commission sought to fill this lacuna. It drafted the surrogacy bill and proposed that Parliament adopt it as an act. The bill was never passed. The court in 2017 acknowledged that. In 2002, the Law Commission suggested an amended version of the surrogacy bill be made a chapter of the new Children's Act. The legislature then set up an ad hoc select committee to make a recommendation regarding the South African Law Commission's proposal. It compiled its own report. Based on this, the legislature enacted Chapter 19 of the Children's Act, which presently regulates surrogacy laws. That took 15 years. In Old Mutual Life Assurance versus Swema in 2004, the SCA, at paragraph 16, with reference to the South African Law Commission report on the division of pension benefits on divorce, which was Project 41, indicated that despite two further investigations by the South African Law Commission, each culminating in a report and a draft bill, none of the recommendations made by the Commission in this regard has yet to be taken further by the legislature. The submission is further bolstered if one has regard to the Commission's historical record in regard to its investigations into the Marriage Act, a Marriage Act in which age for minors of children still haven't been sorted out, Muslim marriages, discriminatory legislation, and Hindu marriages. There can be no doubt that no progress of any meaningful kind has been made on these issues, despite these issues having been part of the Commission's program for more than a decade. So even when the Commission makes concrete proposals, it gets blocked along the way, and it has never ended up in Parliament in the last 27 years. And I make this point because the submissions which Ms. Gabriel made to you to accept the Law Commission process is very similar to the submissions made to the court in 2009. we've got this Muslim marriage bill, it's imminent. We're going to do it. That's what was said to Just Rogers in the Pharaoh matter. We postponed for 10 months because they told us, actually, it's on the parliamentary roll. When we checked, it wasn't. So repeatedly cases, and our papers detail all of this. There have been approbating and reprobating about bills and law commission reports. In a nutshell, there is an infringement of rights in respect of which the state has done nothing. The legislature has not even engaged in this process. And this court cannot, Ms. Pillay, Judge Pillay?
I'm sorry to interrupt you. You mentioned a litany of unfinished legislative pieces, and it reminds me of the Jordan case from this court where the rights of sex workers is still in the balance. But I'm wondering, it seems to me that Ms. Gabriel and you have in mind that there must be some kind of legislative reform. And what's missing from all of this is a plan for legislative reform. Isn't there a basis for a conversation of what that plan should be, whether you would like the court to endorse that plan, and if you're asking for a supervisory relief, whether such a plan might find space in a supervisory order? Have you had a conversation? I'm speaking for myself. I have no mandate from anyone else on the panel.
Justice Pillay, we haven't had such a conversation, and the reason partially why we haven't had such a conversation is that in the High Court, there were 9 counsel representing the state party, 7 for the executive and 2 for Parliament. Parliament was separately represented. The parliamentary defense, as recorded in Justice Bukwa's judgment, was, well,
Ms.
no
Bauer,
initiation.
Even the 10 minutes is up now. Please wrap up within a minute.
Justice, if I can just answer Justice Pillay's
answer Justice Pillay's question, my sister Justice Pillay's question, and within a minute thereafter, please wrap up.
Yes, Justice Pillay. So the position Parliament had adopted in the court of quo was essentially that no bill from the executive had reached Parliament, and so we cannot be accused of not having fulfilled our constitutional obligations. And the High Court found in favor of Parliament. The council currently before court wasn't acting in respect of Parliament. We hadn't engaged on that basis in respect of a supervisory entity. If the court wanted to go down that road and they wanted such engagement, then certainly we would endeavor to reach some agreement. But we have not out of our own done that. The 2 last points that I must make out, Ms. Pillay had made the representations that the 2 protagonist parties had agreed on out of community of property. Your Lordships will be aware that we each put orders before the SCA. Our order is to be found at 1087 of the record, and it's been highlighted, it's not clear. We'll make sure that we send the registrar a copy of a clear version. But our proposition of it not being out of community of property was not accepted by the High Court, by the SCA, my apologies, and that effectively we had suggested a slightly different position in that regard. Justice Madlanga, I'm one question short of not having answered Justice Theron in her question to say to me, can you reconsider the connected 2 persons? May I beg your indulgence to be able to answer Justice Theron's question, which I had realized now as I switched screens, I had omitted to do.
2 minutes, please.
Sorry, Justice Theron, we seem to take on board your suggestion that our proposition in 18.2.1 wasn't clear enough, and we redrafted it to suggest the following. And again, we'll send the draft through. Paragraph 1.8.1 does not invalidate a winding up of the deceased estate that has been finalized or the transfer of property by a party to the marriage that has been effected. unless the property is transferred to a person or legal entity connected to a party. Wait, my apologies, Justice. I'm looking at the wrong one, sorry. Let me start again. Sorry, that unless such property has been transferred to a related person, and we've looked at the Companies Act and then included a paragraph 1.9 that says, for purposes of paragraph 1.8.2.1, a related person means an individual whom is related to another individual as they are married or live together in a relationship similar to a marriage, or separated by no more than 2 degrees of natural or adopted consanguinity or affinity, and an individual in relation is related to a juristic person if the individual directly or indirectly controls the juristic person. So in other words, we've taken on board your concerns that connected to isn't clearly enough, and we've gone back and we've looked at the Companies Act as to what a related person means and inserted that instead. And with the court's leave, we'll email the order through to the registrar for purposes of assisting the court on that revised version. We are indebted to the court for allowing the sharing of minutes, and we are indebted to the court for allowing us this hearing. Thank you.
Thank you, Ms. Bauer, and thank you to all counsel. Before the host terminates the meeting, may I just ask colleagues to check your inbox as soon as the hearing has been terminated. Check your inbox for another link, and please connect on that new link from Mr. Zunaid Naidu. Please.
Justice Madlanga, I apologize for interrupting. Might I inquire whether I would be entitled to a 3-minute reply?
No.
My junior reminds me that I didn't use the 3 minutes that I was given earlier, but it is a question of a reply.
We should have cleared this when I met counsel this morning, because I did indicate I was giving an opportunity for a reply to Ms. Bauer only, and I said 10 minutes then. We should clear things like those when the presider meets counsel in the morning, so that we don't engage in this sort of debates.
Justice, I had understood that was implied, but I may be wrong. I literally only have a minute or two.
Colleagues, may I give Mr. Murphy the 3 minutes? Yes, you may go ahead, Mr. Murphy.
I'm greatly indebted. I only wish to deal with Ms. Gabriel's submission regarding the inconsistency between the legislative order that we seek and the permissive nature of Section 15.3 of the Constitution, and Mr. Willis's point around entanglement. I think there is a bit of a confusion, and this addresses, I think, some of the questions that Justice Pillay has raised. We are not saying that the state has an obligation to pass legislation that recognizes Sharia law. We are not saying that the state has an obligation to pass the legislation that is contemplated in Section 15.3A2, which refers to legislation recognizing systems of personal and family law under any tradition. What we are saying is that the state has an obligation to pass legislation that recognizes the social reality of Muslim marriages. That is different legislation. That is the legislation considered in Section 15.3A1, which is the section does not prevent legislation recognizing marriages concluded under any tradition. So the legislation that the legislature is constitutionally obliged to pass in this case is not legislation that recognizes Sharia law or adopts Sharia law or brings Sharia law into our law or in any way overrides Sharia law. All it does is it recognizes the social reality of the marriage and it makes that marriage subject to secular law. So we are not attempting to make Sharia law enforceable. It may be the case that the legislature chooses to adopt a law which recognizes a system of personal law like Sharia law as law, but that is not the constitutional obligation that we are contending for. There is a middle ground between recognizing and applying a system of personal Muslim law on the one hand, which is a holy inclusion of Sharia law, and on the other hand, what is called a constitution-free zone, which is what Mr. Willis was. That's what his attorney referred to in the High Court as saying that Muslims are entitled to. They're entitled to exercise their religion in a constitution-free zone. These were not my words, they were the words of Mr. Omar. There's a middle ground. We simply recognize the social reality of the marriage, we identify them, and we make them subject to civil law. And the last point is that this question about opt-in, opt-out that Mr. Willis raises in response to Justice Pillay, it's illusory, and it just maintains the status quo. It creates a de facto constitution-free zone, because if people have to choose in advance whether they opt in or opt out, which is what they can do at the moment, of course, Muslim people, since the amendment of the common law, can now opt in to the secular law. The problem comes is that it excludes the very people that need the protection of the secular law at the very moment when they need it, i.e. when things go wrong. That is the marriage that needs to be recognized, is that, and the law needs to come to the aid of that person. So I agree with Ms. Bauer. This case does not require this court to trench in any way on Sharia law. You don't have to understand it, and you don't have to override it in any way. Those are my points. Thank you for the indulgence.
Thank you, Mr. Moultrie. Again, thanks to all counsel. Judgment is reserved. And colleagues, please, let's join the other link.
Today's proceedings have concluded. The host will now terminate the meeting.
George Soros. Does that name ring a bell? I'm sure it does. If you take interest in global trends, popular culture, or geopolitics, you may have definitely come across this name. Let's put a face to it. This is the man we're talking about. He is George Soros, arguably one of the most controversial figures in the world. With as many supporters as detractors, there are reports celebrating his philanthropy, also those questioning his ideas about the world. For some people, Soros is a legend, a financial guru, one of the most successful investors of all time. Yet some believe he's a man of malicious influence, a billionaire who is able to move markets, someone who can sway politics and opinion. So who is the real Soros? And why is he such a polarizing figure? Hello and welcome to Gravitas Plus. I'm Palki Sharma Upadhyay. Have you ever heard of Black Wednesday? It refers to an event in September 1992 when George Soros and a group of investors forced Britain to withdraw its pound from the European Exchange Rate Mechanism, ERM. In other words, they forced the pound out of existence. How is this done? Soros placed an enormous bet against the British pound. He said it would sink below the lowest currency exchange limit. More investors placed their bets, assuming this would happen. Their actions put a lot of pressure on the pound. It sank further, ultimately pushing the United Kingdom out of the ERM. All of these investors made money up to $300 million, but Soros was the winner, earning $1.5 billion in just 1 month. This score earned him legendary status and boosted his firm's wealth to $7 billion. They started calling him the man who broke the Bank of England. Today, they call him a master manipulator of the global order, an unregulated billionaire with a messiah complex. Some say he can bring down not just currencies, but entire systems. Some accusations are indeed far-fetched, but they say there's no smoke without fire. So even if these are exaggerations, what are they based on? Let's look at how much this man is worth. Soros is among the 10 richest hedge fund managers in the world with an estimated worth of $8.6 billion. Some say he's worth way more than this, given the suspiciously enormous sums of money he gives away for charitable causes. He's donated more than $32 billion to a foundation he runs, out of which $15 billion have been distributed in 37 countries. What is this money being used for? For education programs, health camps, human rights movements, justice reform, global governance, and quote-unquote, the furtherance of democracy. How is this done? Through the Open Society Foundation, a name inspired from a 1945 book, The Open Society and Its Enemies. This body is headquartered in New York and has active programs in more than 60 countries. This group gives major grants to organizations and parties that are aligned with its mission and objectives, basically anybody who seeks to shake up the status quo. In Israel, the only democracy in West Asia, the list of grantees of the OSF include a number of Israeli NGOs that deny the legitimacy of Israel. In Palestine, OSF funds NGOs like the Al-Haq and Palestinian Center for Human Rights, both of which are associated with the Popular Front, an outfit designated as a terrorist organization by the US, the EU, Canada, and Israel. What would you call George Soros then? A political activist? Why not? In September 2012, he donated $1 million to a political action committee led by Barack Obama. In 2016, he was the biggest donor to the Hillary Clinton campaign, giving almost $8 million. The move was met with a lot of criticism. He also donated £400,000 to anti-Brexit groups opposing Britain's exit from the European Union, but favored Germany leaving the EU back in 2013. He's a man of convictions and contradictions. In June 2018, Hungary, which happens to be his native country, passed a law dedicated to this man. It's called the Stop Soros Law, aimed at ending OSF funding to organizations that support illegal entry of undocumented migrants. The OSF calls this law authoritarian. Hungary says it is only safeguarding national security. Now, here's the thing. Promoting and funding reform in a system is one thing, but undermining a nation's sovereignty by influencing decisions is quite another. George Soros and the OSF seek to liberate the world from ideas they consider outdated and restraining. They want to change political realities that are not suitable to their principles. Take their activism in India, for example. In January 2020, Soros unveiled a plan to set up a $1 billion fund to build a global network of higher educational institutions that will help students put up a resistance against growing nationalism. He singled out several countries and their leaders. India was one of them. He called India a Hindu nationalist state, which is suffering the biggest and most frightening setback.
The biggest and most frightening setback occurred in India, where the democratically elected Narendra Modi created a Hindu nationalist state.
This was last year. This year, a scandal hit India, the Pegasus Project. It suggested that the government of India was spying on its citizens. The report had a list of 300-odd Indians. Who was behind this project? 17 media organizations and 2 global entities, Amnesty International and Forbidden Stories. They're both beneficiaries of grants and funds from the Open Society Foundation. In 2018, Amnesty received a €137,000 grant from the OSF for a campaign to repeal a law Ireland had passed. In June 2021, just a month before the Pegasus report came out, Open Society Foundation named the former Secretary General of Amnesty as its Vice President for Global Affairs. Then we have Forbidden Stories. It has been proven to receive funds from the US State Department. And guess who do they feature as a supporter on their website? The Open Society Foundation. Here's something else that you must know. Sherpa, a French NGO, which is a persistent litigator in India's Rafale deal with France, has also been a recipient of indirect funds from the OSF through a third party. Simply put, a revolving door spins between these NGOs and the offices of George Soros. The same goes for media organizations involved in this project. The Media Research Center, an American media watchdog established in 1987, says 30 American news organizations have links to George Soros, and most of them were part of the Pegasus project. The project itself is under investigation in many countries. At some point, India too will have to specify its position on surveillance and clear the air on whether it uses softwares like Pegasus. In the meantime, can this nexus between news organizations and George Soros be ignored? Can these links be dismissed as a baseless conspiracy theory? I don't think so. A billionaire is using his power, influence, and yes, his money to make media networks shape narratives across countries and to go after establishments that don't match his vision of the world. Is Hungary, the birthplace of George Soros, the only European country that snoops on its citizens? It was the only one out of 44 European countries to feature in the Pegasus list. Where are Britain and Germany? Where is the United States, the biggest snooper of them all? Are we to believe no one is spied on in these countries? That said, Pegasus is just one piece of this puzzle. The Western media, in cahoots with organizations like Open Society, have had a long habit of canceling the so-called third world countries, countries like India in particular. They see India as a metaphor for intolerance, orthodoxy, ignorance, poverty. Let me show you a few examples of this cancel culture. August 2019, when India revoked Article 370 in Kashmir, the New York Times said, "Bloodshed is all but certain." Note the confidence with which this assertion was made. It's been 2 years. What happened to their prophecy? The BBC, its terminology on Kashmir, IOK, Indian occupied Kashmir. Would they call Northern Ireland British occupied Ireland? Not in this lifetime. The trend is evident. India is seen through filters of bias. Reports based on conjecture indulge in fear-mongering. The idea is not to convey facts or developments. The idea is to validate and propagate prejudice. Why is that only certain points of view from India get featured in opinion pieces? Why are writers selected based on their position against the current dispensation? Why are only organizations with a certain leaning made part of global investigations? They accuse others of bias. What about their own? Look at this headline from 2013, when at least 24 American journalists were given positions in the Obama administration. This included the managing editor of the Time magazine, the national security editor of the Washington Post, a Los Angeles Times columnist, a reporter from the New York Times, a political producer from CNN, and many others, some of whom are also part of the Biden administration. It gets murkier as you dig deeper. There's certainly a nexus that operates to alter political realities the world over, a nexus that runs from the political corridors of liberal powers to the many offices of the Open Society Foundation across the world. And every time this nexus is called out, its ecosystems go on a one-sided rant devoid of facts. Here's wishing them a busy weekend.
Gravitas Plus, co-presented by Škoda, made of smart imagination.